How is everybody?
Good, how are
Still
you?
alive.
Good.
Good.
Thank you.
Oh, let me pull up the screen share. I forgot that. There we go. So I think all is good and ready for us to start. Um, so more of the Commerce Clause today. And I think we've got a pretty good chance of getting all the way through the Commerce Clause. The only question is going to be whether we get into the taxing and spending powers that that follow. You have your slide on there, but it's fairly aggressive, I think, to get there. I try to cover as much as I can because I'd rather not be one of those guys who in the last week of con law covers 600 pages in the book. So that's why I do try to stay on task here. So we're going to continue with the Commerce Clause. Just as a quick review, there are three factors that you need to look at to see whether there is authority for Congress to pass legislation under the Commerce Clause. One is instrumentalities of commerce. That is the exchange of goods and services, and I guess even potentially real estate in the open market, but it historically does not include manufacturing, mining, or other acts of production. It's more on the sales end. The second is the the first one was the channels of commerce. I called it the instrumentalities, I believe. But what I just referred to was the channels of commerce. The second are the instrumentalities of commerce, trains, planes, automobiles, boats, everything that you can use to travel, plus all the methods that are used to travel with them. Roads, railroad tracks, waterways, things like that. And then finally, an activity that substantially affects commerce. This is where the dispute lies, and the originalists want to construe this very strictly and narrowly, and the non-originalists want to restrict it very broadly. What we've started to see is that the originalists want more than a substantially affects Congress. They want it to directly and substantially, not just through indirect means. That's sort of their thing. I just want to make sure that the recording is on, and it looks like it is. Okay, good. We're gonna see this battle continue. Here we got sort of a couple of non-controversial cases, and then we'll get into some controversial cases in a short bit. Our first case here today is Hodel versus Indiana. Anyone know what those pictures are there? Can someone identify what those pictures are of?
They appear to be, looks like a quarry, looks like a rock quarry.
Yeah, rock quarry digging. This is strip mining. Most of us think of mining as in digging a hole in the ground, building a tunnel to go down, and then removing minerals from the subsurface. Strip mining is in many ways a lot easier, where they just go in and they start right at the top and they take out big layers of land. As you can see from this, it's pretty devastating on the landscape. It pretty much, strips the earth of what was previously there. And what the mining companies tend to do, of course, is to leave a big hole in the ground. Sometimes in West Virginia, they literally come in and start cutting off the mountain from the top. So they'll literally start taking all the soil and rocks out from the top, and it will get lower and lower and lower, and we'll just leave it like that. This Hodel case involves a federal law, the Surface Mining Act, and it has some provisions in it called the prime farmland provisions. And what it says is this: if the area that you are mining used to be used for farming and is considered to be within these guidelines prime farmland, then the company that's doing it has to come up with a management plan to show how it is going to restore the mined area to its former self within a reasonable amount of time. This is, of course, much more expensive for the coal companies and companies that strip mine for other ores that come out of the ground. The state of Indiana is not too happy with this either. Obviously, it's losing tax dollars if the amount of mining that goes on is diminished. So the state of Indiana and the Indiana Coal Association sue the federal government, and what they claim is that Congress did not have the authority to do this. And their primary argument, of course, is that this is not the channels of commerce, because we're talking about the production part of the commerce. And historically, production is not considered to be channels of commerce. So the court came in and said, well, no, this substantially affects commerce. And the court comes in and does a very, very broad reading, the majority opinion, a very, very broad reading of the Congress's commerce power here. I mean, look at the quote from the case. A court may invalidate legislation enacted under the Commerce Clause only if it is clear that there is no rational basis for a congressional finding that the regulated activity affects interstate commerce, or there is no reasonable connection between the regulatory means and the asserted ends. What this does is it takes that last factor, the substantially affects commerce factor, and seems to impose a rational basis test. As we're going to see later on, starting with when we do the 11th Amendment and then moving into the Equal Protection Clause and the fundamental rights, whenever you only make the government come up with a rational basis, it's pretty easy for the government to do that. They just have to come up with one sort of half-baked reason justifying what they're doing. What we'll see later on is, in some circumstances, the courts make the government come up with a more difficult standard to meet. Sometimes they'll require them to show an important interest that it's protecting. Other times they'll even require the government to show a compelling governmental interest justifying their activities. So when you say that all the government has to do is provide a rational basis, that can almost be done in every single circumstance. That's not a hard thing for the government to do. Now, Justice Rehnquist, and he's going to be an important guy today. I mentioned to you already the Rehnquist Revolution in the last class. Rehnquist interestingly did not dissent from this opinion. But in a companion case, sometimes the Supreme Court decides similar cases and issues orders on the same day. In a companion case, Rehnquist writes, kind of, I think, giving a hint of where he's going to be going later on. It would be a mistake to conclude that Congress's power to regulate is unlimited. Some activities may be so private or local in nature that they may not be in commerce. The court asserts the regulation will be upheld if Congress has a rational basis for finding that the regulated activity affects interstate commerce, but it has long been established that there must instead be a showing that the regulated activity has a substantial effect on that commerce. Now, the Hodel case was 1981. In 1981, Rehnquist was an associate justice of the Supreme Court. He was not the Chief Justice. He would be appointed Chief Justice in 1985. And that coincides pretty much with the beginning of the so-called Rehnquist Revolution. And at that point, he was able to command a majority of justices who, remember what I said in the last class, who agreed with him that the courts had been too broad, too liberal in construing Congress's power under the Commerce Clause, and it's time to pull back the reins a little bit. So this opinion that he's saying here is a sort of a sign of things to come in the future. And speaking of things to come, we've got the Sebelius case once again. This was the Obamacare case, the Affordable Care Act case. If you recall, the most controversial part of the Affordable Care Act was the individual mandate, forcing you to buy insurance, even if you didn't want to or didn't, have any. You were forced to buy insurance or be penalized when you filed your tax returns with the IRS. And we talked about the economic reasons for that. It was basically creating a large pool with a bunch of healthy people in it to try to offset the cost of dealing with the elderly. A large chunk of the dollars spent on healthcare are spent for people in their elder years. That's when people tend to become sick, and that's when medical care tends to be quite costly. And so they're trying to get young people to buy in who would make the pool a lower risk pool. So, as we mentioned before, there's valid economic reasons for doing that, but that doesn't necessarily mean that there are valid legal reasons for doing that as well. What happens here is we've already looked at the necessary and proper clause argument in regard to the Sebelius case. Now we're going to look at the Commerce Clause argument. And so remember that the reason that the court had to consider the necessary and proper clause argument was because the court had already said that Congress doesn't have the power under the Commerce Clause to do an individual mandate. So now we're about to find out why Congress doesn't have the power under the Commerce Clause to do an individual mandate. And first, we'll start with how the author of the decision, Chief Justice Roberts, John Roberts, how he frames the issue. He says, the government argues that Congress has the power to enact the mandate, the individual mandate, under the Commerce Clause. Under that theory, Congress may order individuals to buy health insurance because the failure to do so affects interstate commerce and could undercut the Affordable Care Act's other reforms. Okay, so he's framed the question, especially in a way that's going to set up his argument, and here's where he goes. He says essentially this. He says, look, all these cases, Wickard versus Filburn, even McCullough to some degree, Katzenbach versus McClung, the Heart of Atlanta Motel case, all really broadly interpreted the Commerce Clause, applied it to things like discrimination, which one wouldn't normally consider to be commerce. But he said, there's one thing that all those cases had in common, which was there was a pre-existing economic activity or commercial activity that Congress was seeking to regulate. So, for example, in Wickard versus Filburn, it was growing wheat to earn a living. In Heart of Atlanta Motel, it was running of a hotel. And so they're regulating and saying you can't do it in a discriminatory way because you're a place of public accommodation. But there was already an existing commercial activity, the running of the hotel. And then in Katzenbach, there was the running of a restaurant, Ollie's Barbecue. So there were pre-existing economic activities. What Justice Roberts is saying here is that that is not the case. Here, instead, there is no other economic activity. Engaging in the healthcare market is an economic activity. So when you go to a doctor, you pay the doctor. Or if you don't pay the doctor out of your pocket, you use your health insurance to pay the doctor. But if you don't go to the doctor because you're young and you don't have any health problems, and you don't go to the doctor because you don't have any health insurance at the same time, that is not commercial activity. That is no activity whatsoever, at least in terms of within the marketplace, within interstate commerce. He says here, what Congress is trying to do is essentially tell these people, you have to buy insurance in order to create the economic activity to then turn around and regulate that economic activity, okay? And he says this is going too far. This opens up a vast domain of congressional authority that the framers never had previously considered. And then this was during oral argument, and then he made what was called the broccoli argument. Hey, just let me stop for a quick second before I get into this point here. I don't know if you guys know this. There's a really great website out there called oyez.org. 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 When the Supreme Court is called into order and the justices walk in, the sergeant at arms, essentially the clerk of courts, says oyez, 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 and then introduces the Supreme Court. This oyez.org has a huge number of the oral arguments that are audio recorded in the Supreme Court. You can actually listen to them. It's free. You can check in and listen to some of the most famous arguments that are going to be made here that for the cases that you can read here. Just so you know, each one, the standard argument is 1 hour in the Supreme Court. Sometimes they'll extend that to much longer. The Obamacare case, I believe, was a full day of arguments. Brown versus the Board of Education, I believe, was either 3 or 4 days of oral arguments. But you can go in and listen to some of the arguments. You'll find it very, very interesting.
How far back do they go? I mean,
well, I think they're adding. I think they keep adding to them. That sounded like Karen. I think they keep adding to them and trying to go back further and further. So I don't know how far back they go. I don't think they have Brown versus the Board of Education. That's not one you want to listen to anyways, because it was what they did was they posed a series of questions. We'll talk about this when we get there, and forced the advocates to argue those questions for these convoluted reasons that we'll talk about a little bit when we get there. But it's interesting. Learning abstractly is never as good as learning concretely, and if you can bring some life to these cases by actually listening to what the advocates, told the justices. And what's cool is you can hear the questions that the justices asked. Of course, you don't know which justice is asking the question, but very often, as I've mentioned, the Supreme Court bar is a small bar. Very often, the advocate will answer a question by saying something like, well, Justice Ginsburg, I would agree with that except for the following proposition, something like, so the advocate might address the judge by name. So, you know, but it's pretty interesting for some of them. And some of them are like watching paint dry. I mean, some of them are just as dull as can be. And some of these cases, you know, don't have the most exciting facts, right? So, okay, back to Sebelius. So, what the court says here is, look, this is how crazy this could get. And Roberts raises the so-called broccoli argument. It's an argument that I believe that Justice Scalia raised during oral argument. And the broccoli argument goes something like this. Okay, if it's good for Americans to have health insurance so that, you know, everybody can get the proper health care they need, and that everybody, and that the government won't deal with people who don't have health insurance and have to pay for the health care out of the taxpayers' pockets, then why can't you do that with virtually anything? And in other words, just as big a problem health-wise is the fact that Americans don't eat very well. Americans eat too much red meat, they eat too much fat. We are an obese society. It leads to diabetes, it leads to cancer, and it leads to heart disease. So why don't we just do this? We're gonna make you purchase a certain amount of vegetables whenever you go to the supermarket, whether you like vegetables or don't like vegetables. And while that might be better for you personally, and might be better for the American society, it's allowing Congress to basically regulate your daily life in a way that was never contemplated. And so, you know, hence the so-called broccoli argument. And then the justice, Chief Justice, ends by saying, look, of course we agree that everyone is going to participate in the market for healthcare, even if they've just been born. Well, of course, healthcare is going to be used when you have been born, but even if they haven't started, you know, going to doctors yet in their lives, they will eventually go to doctors later in their lives, just like they will with food, clothing, transportation, shelter, and energy. That fact alone doesn't give Congress the right to force them to purchase any of those particular goods. And here's a sort of famous line that Justice Roberts closes with, and not closing his whole decision, but closes this point with on the Commerce Clause. It is this, and this expresses the fear of the originalists of having the Commerce Clause become so broad that Congress can do virtually anything it wants, okay? He says the Commerce Clause is not a general license to regulate an individual from cradle to grave, simply because he will predictably engage in particular transactions. And of course, that was the argument from the other side, is that even though he hasn't, you know, even though a person may not have engaged in medical care yet, even though it's clear that medical care is, you know, within the interstate marketplace, just because a person is going to enter that marketplace at some point doesn't give Congress the right to regulate them before they get to that point. There, again, the big thing is there has to be a pre-existing economic activity that is being regulated. Okay, so that's you know, and again, you see you see, remember that this case followed, the Rehnquist Revolution. Rehnquist was dead by now. He was the chief judge who John Roberts replaced. Rehnquist had passed away. So even though the Rehnquist Revolution, I'm not going to say, even though the namesake of the Rehnquist Revolution had died, the Rehnquist Revolution did not necessarily totally and fully die with him. And this is sort of Roberts trying to pull in the reins, just like we're starting to see Rehnquist do as well. And we're going to see even more examples of that in the cases coming up, okay? We've discussed this slide already, so I think we can put Sebelius to bed for now. We're going to talk about Sebelius one more time when we talk about the taxing and spending power that immediately follows the Commerce Clause. Now, what Chemerinsky does is we just looked at, he's breaking up cases in terms of topics. We just looked at some regulatory cases. Now we're going to look at the Commerce Clause being used to justify federal criminal laws. And again, remember that when the Constitution was created, there was no body of common law that the federal courts got to work with. I'm oversimplifying the point a little bit, but it's still pretty much a valid point. Instead, criminal laws had been dealt with by the states through a combination of common law, which is judge-made law, and statutory law. Originally, there was no statutory law, and then, first in Parliament in England, the legislature started to create criminal statutes. And in the United States, obviously, state legislatures started to create criminal statutes as well, okay? So here, the federal government is now enacting criminal laws. The Constitution gave it some authority to do so in Article 1, Section 8, but what cannot be found specifically in the enumerated clauses in Article 1, Section 8 will usually be picked up by the Commerce Clause. And the argument would be that the Commerce Clause gives authority, which means that most of these criminal laws we're about to discuss have some type of economic overtone. There's some type of economic interest involved. So our first case is, and this might be our only case on this, by the way. We'll talk about it more later, sort of incidentally. Perez versus the United States, a case about a loan shark. And you know what the loan shark is, right? I kind of like the way the court describes Mr. Perez here. There was ample evidence showing that Perez was, quote, one of the species commonly known as loan sharks who used the threat of violence as a method of collection. Now, Mr. Perez doesn't really, in this case at least, doesn't really argue that he's not a loan shark and should not have been found guilty. What he argues is that Congress has no right to create this Federal Consumer Protection Act to prohibit extortionate credit transactions and use it against me because if I was a loan shark, I was only a loan shark within the four corners of my state. And this was a local crime. And you should leave it up to the state to prosecute me. And I've mentioned this before, and I'll mention it again. Anyone who commits a crime, that's a crime both under state law and federal law, would be very pleased to have the only charges brought under the state law, because the sentences and penalties under the federal law are almost always substantially greater than under the state law. For example, there is a federal death penalty. Many states do not have state death penalties, right? You guys understand that Sarnaroff was tried in a federal court on federal charges and had received a death penalty. If he had been charged with murder, or assault with intent to kill, under Massachusetts law, the stiffest sentence he could have faced was life imprisonment. An example of how the federal penalties tend to be a lot stronger than the state penalties. One other thing, the assistant U.S. attorneys in the criminal division of the various U.S. attorney offices, they don't mess around. They go for you. And once they get you, there's an excellent chance you're going to be found guilty. Mr. Perez is going to be happy if he can get the federal charges against him dropped. So he says, this is purely local. You need to leave this up to the states. The court said, no, we have Congress has the right to pass this law. And Justice Douglas, William O. Douglas writes the decision. A quick little primer on what we've talked about already. He goes through the factors that we talked about before, channels of commerce, instrumentalities of commerce, and activities that substantially affect commerce. And here we're talking about the third category, the last category. Clearly, credit transactions, whether extortionate or not, affect interstate commerce. Organized crime has a substantial impact on interstate commerce. And we would even then come to see the federal government passing laws like RICO, the racketeering statutes, that were used fairly effectively to help break up, to a large degree, not entirely, help break up the mafia and other organized crime groups. Okay, now this is where a lot of the jurisprudence is happening today. The interplay between the 10th Amendment and the Commerce Clause. If you remember, I mentioned this as one of the three things that the Supreme Court used in the laissez-faire era, right? Which ran from 1890s until 1937. And that is this: well, maybe it does violate the Commerce Clause, but it intrudes on states' rights a bit too much. And now, again, we're going to get into this question of states' rights versus federal rights. And, the judges who want to interpret the Commerce Clause narrowly generally want to favor states' rights over federal rights. And the Supreme Court can't do much about states' rights, by the way. And the judges who want to interpret the Commerce Clause broadly generally do so because they favor federal rights over states' rights, okay? So here we go. Let's start with what the 10th Amendment says. It's pretty pithy, not much to it. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Again, this harkens back to our discussion of enumerated power versus reserved power, right? So you've got the 17 specific enumerated powers in Article 1, Section 8, tacked on to by the Necessary and Proper Clause. Then you'll find a couple of other powers in other spots in the Constitution. But that's generally it. There's a finite number of powers that the federal government gets to exercise. All the rest is left up to the states, and the 10th Amendment said this. Just a tiny little background before we go on. The Continental Congress wrote the Constitution in 1787, in largely the summer of 1787. And it was ratified in 1789. While it was being ratified, it took 2 years. While it was being ratified, it was not a fait accompli that it would be ratified. They needed 9 of the 13 states to ratify it for it to become the law of the land, essentially, what the delegates agreed to when they met at the Constitutional Convention. One of the things that happened was that a lot of people wanted the Constitution to provide for individual rights that protected individuals from the government. And they essentially wanted what would become the Bill of Rights, the first 10 amendments to the Constitution. And so what happened in the 2 years of ratification, and by the way, the framers of the Constitution did not want a Bill of Rights. They did not want these individual rights to be stated. They wanted the individual rights to be left to the states, okay? What they did was they purposely didn't put them in because they didn't want anyone to construe that there might be reserved power to the federal government, you know, the power to deal with free speech issues and things like that. So they didn't put it in, but when it looked like the Constitution might not be ratified, Madison, you know, the guy who essentially drafted the Constitution, turns around and drafts the Bill of Rights. And the process of getting the Bill of Rights out to get ratified starts as well. And it's used to prop up the Constitution to help get the Constitution ratified. So the Constitution is ratified in 1789 with the promise that the Bill of Rights is on the way, and indeed the Bill of Rights is on the way, and the Bill of Rights comes and is ratified in 1791, just 2 years later. And to make sure that the Bill of Rights was not going to, you know, broaden federal power, the 10th Amendment is tacked in at the end. It's interesting, the 9th Amendment and 10th Amendment almost conflict with each other. The 9th Amendment says, the powers enumerated hereunder shall not be construed as to limit the authority of the federal government. And then the 10th Amendment says the powers not delegated by the Constitution are reserved to the states. Not a direct conflict, but they seem to be talking at cross purposes, which is interesting. So you know, that's a little bit of the backstory here with the 10th Amendment, and it's solidifying what the framers pretty much knew, which was, you know, all other than enumerated power is reserved to the states. And obviously the federal government and the federal courts have no ability to limit the states in what they construe to be this reserved power, unless it conflicts with one of the enumerated powers that the federal government has. So your author, Chemerinsky, starts us off here with a note. And the note essentially tells us about the case of a National League of Cities versus Ussery. Ussery was then the Secretary of Labor. What happened was that in the 1970s, there was a federal minimum wage. And you guys understand that today there is a federal minimum wage. I can't even tell you what it is. It's relatively low. I think it's $6 or $7 or something like that. And I think a lot of the
It went up higher. I think there was a big thing about it, and it's much higher.
Karen, it has not been raised in decades.
Oh, real, oh, I'm thinking of
Um,
something else then, sorry.
Yeah, no, you're thinking of the states. So most states also have minimum wages. And I think, isn't the Massachusetts minimum wage like 11 or 12 bucks an hour, something like that?
Yeah, that's what I was thinking of, sorry, yeah.
Yeah, and that's been raised, and states raise them all the time. And I think one state, like Washington State or one state, recently raised their minimum wage to 15 bucks an hour. There's been talk of that. So in any event, there's a federal minimum wage, and it applies to everybody, including employees of state governments. So here, a couple of the states complain, and they say, this Fair Labor Standards Act, FLSA, should not, okay, it's fine to impose this on our private citizens. We don't have a problem with that. But when you're imposing it on those who work for the state, you are violating state sovereignty. You're essentially interfering with state rights. So even though under the Commerce Clause, this is clearly, a minimum wage, clearly is a regulation that deals with commerce, that deals with interstate commerce, certainly substantially affects interstate commerce. Even though that's clearly the case, this interferes with state rights, with the rights reserved to us under the 10th Amendment. And the court here agrees with the states. The court says, here's the language, the minimum wage violated the 10th Amendment because the law, quote, operates to directly displace the state's freedom to structure integral operations in areas of traditional government functions. This would displace decisions traditionally leaving to these matters to the states, and may, quote, substantially restructure traditional ways in which the local governments have arranged their affairs and interfere with traditional state and local government functions. So, the bottom line is that, the states, you know why the states don't want to pay their bus drivers, their highway department workers, too much money, is because it's going to come out of the taxpayers' pockets, essentially. It's going to come out of the state coffers. And that should be left to them to deal with. That's the argument here. Well, 9 years later, Ussery is essentially overruled with Garcia versus San Antonio Metropolitan Transit Authority. Almost the exact same case, virtually the same fact. The transit authority workers are required to be paid the federal minimum wage. Obviously, the Texas minimum wage is less than the federal minimum wage. And so the San Antonio Transportation Authority challenges this, and in a 5-4 decision, the majority overruled Ussery and changed the result. And here's essentially what the court said. The court said, look, when it comes to regulations, there's nothing preventing the federal government from regulating activities in which the state engages if it's within interstate commerce. This has nothing to do with state sovereignty, okay? In fact, there are areas where there's overlap between state law and federal law all the time, and the framers of the Constitution contemplated this and gave us the Supremacy Clause. So the Supremacy Clause says if a state regulates in an area and the federal government regulates in an area, then the state law must yield to the federal law because the state law is preempted by the federal law. We're going to talk about preemption. It's a big topic that we're going to talk about later on, okay? And this was contemplated by the framers, and they go on. They say, look, there's plenty of ways that state sovereignty is protected here, just in the very structure of the way, the federal government and the concept of federalism, the relationship between the government and the states were created. Every state gets equal representation in the Senate, even if it's got relatively few people. There's an electoral college. Initially, the state itself, well, even today, the state itself gets to choose electors. That's getting a little more complicated. The senators initially were not even elected by the people themselves. They were elected by state legislatures. That changed with the 17th Amendment later on. So the court here concludes that the structure created by the framers protects the states from an overreaching federal government in other ways. And there doesn't have to be this fight between the Commerce Clause and the 10th Amendment, is the way the majority is now looking at it. Now, the guy who wrote Ussery was Lewis Powell. And the guy who dissented in Garcia was Lewis Howell. And his dissent was fairly bitter. First of all, he says it's only 9 years. At one point, the Supreme Court was very hesitant to overturn cases at all. And they were really hesitant to overrule or overturn cases that were relatively young. And in the scheme of things, Powell considered 9 years to be not that long ago. And so he complained about that. Unfortunately, what the Supreme Court likes to do is it likes to pretend that it's not overruling a case and then carve out exceptions or somehow make an argument that sometimes is a little stretched that says that that case does not apply here. I think we saw that back in when we were doing prudential standing and we talked about taxpayer standing. Remember, we said the one exception to taxpayer standing was the Hine case when it applied to the appropriations, legislative appropriations of funds in alleged violation of the Establishment Clause of the First Amendment. And then the next two decisions, the court essentially refused to apply the Hine case without overruling the Hine case. So that's a fairly typical way that the court goes about doing this. And then Powell says, you just have it wrong. Powell's a big states' rights guy. Wanted a limited federal government. He happened to come out of the financial world. He was a big Wall Street roller before he was a judge on the Supreme Court, and was not all that interested in seeing securities law highly regulated. So, he was from that camp, but I'm not saying that as a criticism of it. People tend to bring their experiences to them when they come to the Supreme Court. And then came Rehnquist. There was an old TV show called And Then Came Bronson, about a guy who drove around the United States on a motorcycle and had various adventures. Kind of a dull show, by the way. I don't think it lasted that long on TV. I think it was on in the 60s, if I remember correctly. So, and what I really should be saying here is then came the Rehnquist revolution, so to speak. Remember, the goal of William Rehnquist was to pull in the reins on the expansion of the Commerce Clause. And he might not have admitted this, but I think most people would have observed that not just pull the reins in on the expansion of it, but even pull the reins in from how far it had gone. Essentially, he thought it had gone too far. And so here we go. We got a couple of cases coming up by who was by then the chief on the Supreme Court, Chief Justice Rehnquist. The first is United States versus Lopez, 1995. young Mr. Lopez was a senior in high school who decided it was wise to carry a concealed weapon into his high school on a particular day. He was discovered. He was 18 years old. He was charged under Texas law with firearm possession on school premises. And many states, including Massachusetts, have a rule prohibiting firearms in a school zone, right? I think we're familiar with these types of laws. We're gonna see in a minute what happens when the federal government wants to do the same thing, okay? So Mr. Lopez is charged by federal agents when they discover what went on here. He's charged with federal agents of violating the Gun-Free School Zones Act of 1990. The Gun-Free School Zones Act of 1990 did the same thing that many of these state acts do. It forbade an individual from knowingly possessing a firearm in a place that he knows is a school zone. He's found guilty. He's sentenced to 6 months imprisonment and 2 years of supervised release. Mr. Lopez then appeals the decision all the way up to the Supreme Court. And 5 of the justices of the Supreme Court, enough to comprise a slim majority, reversed Lopez's federal convictions. And it said, look, this doesn't really have to do with channels or instrumentalities. He's not selling the firearm. He's not being charged with purchasing the firearm. He's being charged with being in possession of the firearm. So, you know, really what we're dealing with here comes down under the third category. Does his activity substantially affect interstate commerce? And here come the two sides of the argument, okay? The minority opinion, those in dissent, say the firearm, look, these arguments are right out of Heart of Atlanta, right out of Katzenbach versus McClung, right out of Wickard versus Filburn, right? Okay, well, while being in possession of a gun is not itself an interstate act, the gun traveled into the state by commerce. It was purchased by someone in interstate commerce, and there's a good chance that someone then gave it to Mr. Lopez if he didn't somehow purchase it himself. And looking at the whole picture, this substantially affects interstate commerce. Plus, we're going to make another argument, and this one was made in Heart of Atlanta and Katzenbach as well. This has a negative effect on interstate commerce. If kids aren't safe in their schools, this is going to interfere with the learning process. And if it interferes with the learning process, we're going to have a less educated populace. And we have a less educated populace, we're going to have a populace that is underemployed and that does not economically contribute to society as much as it could, okay? You see the point? These are all more indirect economic arguments. You know, him just holding the gun was not necessarily, or him having the gun in his pocket was not necessarily an economic activity. It was a crime, but, you know, under state law, it would have been a crime, but not necessarily an economic activity. So what Rehnquist is saying here is that purely local crimes are not enough to rise to the level of authority that's required under the Commerce Clause, okay? Despite all the indirect economic arguments that it should be. This is how Rehnquist is looking at this this here. And this fits right in with, these guys. Actually, there was one woman on the court at this time, Sandra Day O'Connor, with their concept of federalism, which is that local crime should be left to the states. Murder should be left to the states. Domestic relations should be left to the states. Education should be left to the states, not to the federal government. And so here's what Rehnquist says. And again, it's the Rehnquist revolution is essentially saying it's not just substantially affects interstate commerce. It's got to directly affect interstate commerce as well. You look at the specific activity, possession of a firearm. You don't look at all the economic circumstances surrounding it. You only look at the possession of the firearm. And the broad constructionists will say, you've got to look at, all the economic circumstances surrounding it, okay? So here's Rehnquist. To uphold, in the first sentence, you're going to hear this again, over and over, and quoted in other cases. To uphold the government's contention, we have to pile inference upon inference in a manner that would bid fair to convert congressional authority under the Commerce Clause to a general police power of the sort retained by the states. Additionally, some of our prior cases have taken long steps down that road, giving great deference to congressional action. The broad language in these opinions has suggested the possibility of additional expansion, but we decline here to proceed any further. To do so would require us to conclude that the Constitution's enumeration of powers does not presuppose something not enumerated, and that there never will be a distinction between what is truly national and what is truly local. This we are unwilling to do, okay? So leave, this type of thing to the states, okay? We have more to go here. As I say, notice the obvious departure from Wickard, Heart of Atlanta, Katzenbach, all of which were premised on indirect economic effects of commerce. This is pulling the reins in and saying you only look at the direct activity that is going on, nothing beyond it. Then we come to United States versus Morrison, which involves the federal Violence Against Women Act. Some call it VAWA, V-A-W-A. Congress passes this in 1994. And what this does is, first of all, it provides for crimes against perpetrators of violence against women. But it also provides a civil remedy for women who are the victims of violence in interstate commerce. And unfortunately, we see this reoccurring story in American society. I'm the biggest sports fan of them all, but we tend to place our sports in the United States on too high a pedestal, and give special privileges to our athletes. This occurs not only in regard to professional athletes, but it seems to also occur in regard to collegiate athletes as well. Virginia Tech, big football school, obviously. This co-ed Christy, I think it's pronounced Berzonkala, claimed that she was assaulted and repeatedly raped by two members of the Tech football team, Morrison and Crawford. There's a school disciplinary hearing, and Morrison admits that he had sexual contact with the alleged victim, even though she had twice told him no, don't do it. Morrison got a suspension out of this, but later the school administration struck it down. He must have been a pretty good football player at the end of the day. The state grand jury did not find sufficient evidence to charge either Morrison or Crawford with a crime. So Berzonkala goes out and files a suit under the Violence Against Women Act. Same ruling as Lopez, same logic, same ruling. Local crime. There is nothing economic about rape. The act of rape does not involve interstate commerce. Now, even though, you know, the effects of rape may have that, you know, deleterious effects on interstate commerce, which is what the dissenters argued here, especially on the college campus, interfering with, you know, the educational process and the like. The court says, no, these are, you only get to look at the act itself. Is the act itself an economic act? Is it economic in nature? And if it's not economic in nature, it is a purely local crime, and it must be dealt with purely by the local authorities, and that the federal government cannot get involved. And so her case was thrown out, and that part of the Violence Against Women Act was deemed to be unconstitutional, okay? Here he's saying, he doesn't say layer upon layer, he says attenuated effect, you know, not a substantial one on interstate commerce. There's the government's argument citing Wickard versus Filburn, a mountain of evidence showing the substantial effect on interstate commerce, but the majority says no, this is a purely local crime. Commerce Clause does not give Congress authority to criminalize on the federal level purely local crime. That's what these cases stand for, okay? I mean, you know, these slides are just more of the I've kind of bottom lined it here for you. You know, Rehnquist and the other four justices who signed on to his opinion see this as a federalism issue, and they see it as the erosion of states' rights at the expense of growing federal power, okay? Can we all agree? Can we all agree that Wickard v. Filburn is essentially dead? That the Supreme Court in the Rehnquist Revolution is saying that, you know, these attenuated or indirect effects on interstate commerce are enough? They have to be direct, right? Okay, wrong. Then came drugs. Specifically, then came Gonzalez versus Raich. This is Wickard v. Filburn, but it involves marijuana instead of wheat. This is the same case I purport to you, okay? By this point, it appears to everyone, this case shocked me when it came down. I thought this case was going to go in the other direction when it came down. So guess what the court is willing to do this time? When it comes to drugs, not when it comes to firearms, not when it comes to rape, but when it comes to marijuana, the court is willing to revive Wickard versus Filburn. And that's what it does here. So you've got these two women, and they're elderly, they're in bad health. One of them just seems to have a whole series of constitutional medical issues. The other one was in an automobile accident and suffers from pain. They and their caretakers bring this lawsuit because they're being charged under the Federal Controlled Substances Act with growing marijuana plants in their house. Apparently they have grow lights, they're doing them in the basement. How this was discovered, I don't know. California has no interest in prosecuting, even as early as 2005. I know there's a trend for states to decriminalize or even legalize marijuana. This would have been a little early in the game. But California was looking the other way, at least, in regard to prosecuting marijuana cases. These women say that, look, everything we grow is for personal consumption. We don't sell it. We don't give it away. We have serious medical reasons to have that. I think one of them has a doctor who signs an affidavit that says if she doesn't get her pot, she's going to die. And I think he's saying it literally, not figuratively here. So this case comes up in front of the court, and this time Justice Stevens writes the decision, who later in his career tended to be lumped in with the liberal side of the court, not the conservative side of the court. And he says, look, Wickard versus Filburn is right on point. And you thought it was dead. You know, there's a huge illicit market in marijuana. And these women, although they're not putting this stuff into the market right now, you know, may be tempted to do so at some point. The court didn't get to write about Breaking Bad, did it? Where you have a high school chemistry teacher who ends up entering the methamphetamine trade. He starts producing it and selling it. Sometimes the lure of the money is just too much. Because of, you know, even though it's a minute, a tiny, tiny, tiny impact by these two women on interstate commerce, the cumulative effect is enough to say that it substantially affects interstate commerce. And Wickard comes back again. Sarcastic people think that the court has a problem with drugs more than it has a problem with rape, and that it has a problem with illegal firearms possession. You see where the court is coming down here. I have trouble squaring these cases with Lopez and Morrison. If having a firearm in your hand is a purely local crime, if rape is a purely local crime, isn't growing marijuana in your own basement for your own personal use a purely local crime in the same way? So I have trouble squaring these. And this is one of the reasons why I say we're all guilty of this, guys. We're human beings. This is one of the reasons why I say when it comes to the Constitution, we're all hypocrites. We're willing, you know, here you've got these originalist judges signing on to this decision who were trying to pull in the reins on the Commerce Clause, saying you can't have federal statutes that prosecute for purely local crimes. And all of a sudden, well, it's drugs. And I got a problem with drugs. I'm a Scotch guy, not a pot guy, right? I got a problem with drugs. And so all of a sudden it's, hey, Wickard doesn't look so bad to us right now. You know, that's human nature. But it messes up law students. How do you guys, when you get a fact pattern, how do you guys know which side to take? Well, that's easy, right? What you're going to do is you're going to argue both sides of the issue. You know, Lopez and Morrison would seem to indicate this is a purely local crime. And the Supreme Court has said purely local crime should be, under the 10th Amendment, should be left to the sovereignty of the states to deal with, not to the federal government. At the same time, Raich versus Gonzalez, which came after those cases, seems to take a divergent view, okay? So, you know, the court kind of bouncing around on it. Okay, now we're going to talk about a new concept. Well, I'm not going to call it a new concept. A new factual situation.
No multiple choice quiz.
No, this is a multiple choice quiz.
Bummer.
Yeah, a new factual situation. these next two cases are going to be what are known as the anti-commandeering cases. You guys know what commandeering is? Essentially, one of the reasons that the War of 1812 was fought was because it was between the United States and Great Britain, and the British Navy had the most powerful, still had the most powerful navy in the world, and they would sail off the coast of the United States, and they would literally capture American boats, and they would take the sailors on them and commandeer them into the British Navy. They would, essentially create human bondage. They would make them become British sailors. They called it impress. They impressed them into
Isn't
the
that
British Navy.
Shanghai? Isn't that the term Shanghai?
Yeah, I guess. Yeah. I mean, it's Herman Melville's book, Billy Budd, was based on that activity. Everyone knows, Moby Dick, but he had another important literary work called Billy Budd, about an American who got impressed into the British Navy. So these two next cases are the anti-commandeering cases. On the bar exam, you might see an answer that says no, because the federal government is not allowed to commandeer state legislatures or state officials, okay? Now, this first state case, New York versus the United States, is about commandeering state legislatures. And the proposition that it stands for is that the federal government cannot enact a statute that's justified by the Commerce Clause that says you are required to pass this following statute in your state. Okay? And more specifically, New York versus United States says you are not allowed to pass a state statute that conflicts with this federal statute. Okay? So sometimes it's used with the legislature. You don't have commerce power. The federal government does not have the power, by saying, well, it's good for the economy, does not have the power to tell state legislatures they have to enact specific statutes, okay? So, for example, if we wanted to have a national response to COVID, could Congress pass a law that says all of the 50 states are hereby required to pass a law that requires people who are in public and less than 6 feet apart to wear a mask, and then provide for enforcement of that statute? And the answer is no. That would violate the anti-commandeering provisions of these cases. You can't force a state legislature to do the federal government's bidding for it, okay? It's violating the 10th Amendment. It's interfering with state sovereignty. And then the second case we're going to look at, the Prince case, P-R-I-N-T-Z, not like Prince Spaghetti, which is P-R-I-N-C-E. The Prince case says just like you can't commandeer legislatures, you can't commandeer state officials. You can't commandeer state police officers to do federal enforcement. You can't commandeer state police chiefs to do tasks on behalf of the federal government. That violates our federalism principles. You're violating the 10th Amendment by interfering with the state's sovereignty, okay? And I think the Prince case is a little bit more clear and understandable than this New York versus United States case. So let's look at New York versus United States first. At one point, we were building a lot of nuclear energy facilities in the United States. It was viewed as being would eventually become a more cost-efficient way of providing energy, and it has the great advantage of not putting greenhouse gases into the atmosphere. But there was always a big problem with nuclear energy that we didn't seem to have the political will to solve. And that was this. Although nuclear power does not put carbon-based materials into the atmosphere, it does create waste, just like coal plants create waste, just like the burning of gas creates waste. Okay, with coal and gas, that goes into the atmosphere as greenhouse gases, as carbon-based gases. With nuclear power, the waste is nuclear materials that have gone through nuclear fission and that are highly toxic. And so these rods, after their useful life is done, have to be disposed of somewhere. Now, at one point, there was a plan to take them all, build a huge underground facility in a mountain, I think it was called Iron Mountain, on the California-Nevada line, and have, and place this stuff in these tunnels that were built way underground where nuclear waste wouldn't get out. The problem with that was, you guys know what a NIMBY is? N-I-M-B-Y, you've never heard the term NIMBY? Hey, that's a great idea, but not in my backyard, right? That's a great idea, but do it somewhere else. And so, the states didn't want this, number one. And number two, the states didn't want trucks passing through their state, bringing this material to another state. And so there was never a political solution to dealing with this problem, which is a shame. Because this is a far bigger risk than an actual nuclear meltdown. We had a partial nuclear meltdown at 3 Mile Island. We had a major disaster that killed thousands of people in Chernobyl in Russia. But the United States hasn't, thank God, hasn't had such a problem. And we haven't built nuclear power plants in a long, long time because they're just not economically justified in doing so. So here, this was an attempt at a solution. There's a compact between these states of how to safely deal with their nuclear waste. And they get incentives for taking the nuclear waste of other states. So the idea is to try to encourage states to want to take the nuclear waste. And New York entered this compact that's approved by Congress. And the Congressional Act said this, is that if you refuse to enter into one of these compacts to take nuclear waste or to agree to send it to a place who's agreed to take it, you have to pass a law that requires you to take title to the nuclear waste, okay? And Justice O'Connor wrote this opinion, and she said, no, this is commandeering. The take title provision is commandeering. You are forcing state legislatures. The states that don't pass this will lose, money from the incentives of taking it, and they have to choose between the money and from the coercion of taking title to it, making sure that they provide for it themselves. And she says this violates the anti-commandeering provisions of the 10th Amendment. Now, I think the Prince case is a much more straightforward case. When I used to teach con law, everyone remembers the day that Ronald Reagan was shot. There are a few things in the world that you remember. I was very, very young, but I remember the day that JFK was shot. I remember the night that RFK was shot. I remember the night that I was told the next morning by my mother that MLK, Martin Luther King, was assassinated. I remember the night that John Lennon was assassinated. And I remember the day that Ronald Reagan was shot, about a year after he became president. Interestingly, both John Lennon and Ronald Reagan were shot when I was in law school. And so I'm used to talking about these things as if people remember them like I do. But the problem is, of course, most of you, in my day class especially, most of you probably weren't even born.
I
when
remember.
Reagan was shot. Yeah, I mean, I remember. I can tell you, I was in a car with two other law school friends on the Tobin Bridge, and we were we left campus. We're heading over to Revere to go to Kelly's Roast Beef to get a Kelly's Roast Beef sandwich, and it came on the radio. So you know, you remember distinctly when those things happened. And then, you know, later on, I got home and I saw the videotape of what happened, and you saw a Secret Service agent literally jump in front of John Hinckley and take a bullet to the gut in order to protect the president. That's what they're supposed to do. He lived. And then the president's press secretary, Jim Brady, who was standing next to President Reagan, it was only a .22 caliber firearm. It wasn't a very, you know, a big caliber. It can still kill people. Jim Brady took a bullet to the forehead, and as a result of it, sustained permanent brain damage. Not of the type that made him a non-contributing member to society, but it caused him to first have to be in a wheelchair and then eventually need crutches to walk, and to have speech impediments and things like that for the rest of his life. After this happened, Congress passed the Brady Handgun Violence Protection Act, which essentially tried to create a portion of which tried to create a registration system for firearms. And the way that it did it was, in order to buy a firearm, you would have to go through the federal system of complying with this. The person purchasing the gun in a store, in a gun shop, would have to fill out this Brady form giving a whole bunch of personal information. And then that information would then be put into the federal system. If, say, the person purchasing the gun was from another state, the feds would contact the CLEO of the town where the person was from. A CLEO is a chief law enforcement officer. Would have to contact the CLEO of the town where the person was from, and have a background check done by the CLEO within 5 business days. A number of CLEOs in Arizona objected to this. They didn't want to do federal functions at the state level. You know, the argument is we're getting paid by a subdivision of the state of Arizona, the counties or the municipalities of the state government where we live, and we're being forced to do federal actions when we're not federal employees. And, you know, at its core, I think you can see the argument fairly easily, right? At its core is there'd be no such thing as state authority if the federal government could grab all the federal employees and say, you have to do this, this, and this for us. And by the way, we're not going to pay you. You have to rely on your state paycheck in order for that to happen. And that's the way that these CLEOs saw it, and that's the way that the Supreme Court saw it as well. Another Rehnquist decision. I'm sorry, this was by Scalia. Rehnquist was still alive. Rehnquist died in 2005. So Scalia refers to the dual sovereignty, federal government, state governments. This is clearly commandeering state employees to do tasks at the federal government's behest. The federal government cannot draft police officers of all the 50 states into its service. This would increase the power of Congress well beyond what the Constitution intended. Okay. And then in 2000, we have Reno versus Condon. By this point, we're starting to see the danger of private information. It used to be pretty easy to keep our private information private until the internet came along. And once the internet came along, of course, all of our private information was out there for people who had the knowledge and the means to do so, just to grab it through illicit means sometimes. I'm old enough to remember that my driver's license number was my social security number. There it was, right on my driver's license. My social security number was right there.
It was
And of course,
easier
your
then,
social,
yeah.
yeah, your social security number is, can unlock a lot of private information about you. And it can be used to steal your identity once you get some more information. So South Carolina had this policy where anyone who fills out a form and pays a fee can come in and obtain all the information that they have on any person who has a driver's license in the state. And of course, a lot of information gatherers do this for advertising purposes, for solicitation purposes. Well, the federal government, Congress, passes the Privacy Protection Act of 1994, and they create this regulatory scheme that prohibits the states from disclosing certain private information from a driver's license without the driver's consent. And South Carolina says, geez, we're going to lose a lot of money here, but we see this as a commandeering of our laws, much in the same way that the New York versus United States case did as well. This time Rehnquist says, no, this is not commandeering. This does not go too far. It doesn't require the states to abdicate their sovereign capacity. It doesn't require them to regulate. This is just a federal law, and it would preempt state law that conflicts with us. It doesn't tell South Carolina it's going to go and pass anything. It also doesn't tell South Carolina that it's not allowed to pass anything. So Rehnquist says this is okay. And I believe this is our final case. This is our final case in the Commerce Clause. And hopefully we'll get through, I got 11 minutes. Hopefully we'll get through this case, the Murphy versus NCAA case, and the in the multiple choice question that I have at the end. And we'll start taxing and spending on Tuesday. I don't mean I want to start taxing you or spending for you on Tuesday. We're going to start the taxing and spending powers. By the way, as I'm sitting here looking at the soccer ball right now, I said Americans are sports crazy, too much so. Does anyone know any European or South American soccer fans? They might be as crazy as we are. So, okay. So Murphy versus NCAA is all about sports gambling. And the Professional Amateur Sports Protection Act, the PASPA, makes it unlawful for states to permit sports gambling through their laws. So the states, it essentially bars the states from enacting any laws that recognizes sports gambling. And by this point, most of the sports gambling that they're talking about is online sports gambling. What are the DraftKings is, I think, is a big one. You know, these games, rotisserie baseball and rotisserie football, turned into these extravagant software packages that let you play games and gamble online, essentially. Then there's a lot of card playing online as well. So New Jersey challenged this because they were initially grandfathered. They were one of the states that were grandfathered. But then after the grandfathering had ended, the law was passed, and they said, no, we don't want to allow sports gambling online. They had to change the heart, but it was too late. And so they sued, and they said, you know, this is, you're commandeering our legislature. You're telling us the legislature cannot change New Jersey law to allow sports gambling. And Chief Justice Roberts wrote the decision and said, yes, this is commandeering. This violates the anti-commandeering rule. Congress may not simply commandeer the legislative process of the states by directly compelling them to enact and enforce a federal regulatory scheme, okay? So, you know, it's a bit more like the New York versus United States case. So let's take a look at this right here. A pretty straightforward multiple choice question, and we'll end with this. A federal statute makes it a crime to take a motor vehicle that has been transported, shipped, or received in interstate or foreign commerce from the person or the presence of another by force and violence or by intimidation with the intent to cause death or serious bodily injury. So this is essentially a federal carjacking statute, right? It makes carjacking a federal crime. A defendant charged with violating the statute claims the case against him should be dismissed because Congress lacked the authority to enact it. Did Congress have the authority to enact the law? A, no, unless the government can prove that carjacking has a direct and substantial effect on interstate commerce. B, no, because violent crimes such as carjacking are areas of traditional state activity. C, yes, because cars are instrumentalities of interstate commerce. D, yes, because crimes like carjacking represent a kind of forced wealth transfer that is economic, albeit illegal activity. Okay? Anyone want to speak for one of those? Anyone want to speak for D? Don't speak for D.
I like C.
Whenever you see a bar exam answer that has this sort of debatable social or economic policy put into it, it's always a wrong answer. And wealth transfer is a big topic that the Republicans and Democrats fight over all the time. They accuse each other of engaging in wealth transfer. Republicans seem to be afraid that the Democrats want to steal it from the rich and give it to the poor. And the Democrats think that the Republicans want to steal it from the poor and give it to the rich. That's not a law question, essentially. So Karen likes C. Well, look, if this falls within one of the three factors that we looked at, channels, instrumentalities, or substantially affects, then Congress has power to do it, okay? And even if this carjacking did not involve crossing state lines, it was a carjacking that we're talking about, right? And what's the name of the movie that goes along with instrumentalities? Trains, planes, and
Automobiles.
automobiles. A car is an automobile. A car is an instrumentality of state commerce. The fact that this is a regulation in regard to automobiles is enough to bring it within the authority of Congress. So C is the best answer, okay? A is debatable because I put that word direct in there, and the Supreme Court, depending on the day, seems to require a direct economic effect on commerce, a direct and substantial effect on commerce, and on other days does not. Obviously does when it's Gonzalez. I'm sorry, when it's Lopez or Morrison, but not when it's Gonzalez. B is normally true that violent crimes are areas of traditional state activity, but at the same time, if it has something involving commerce, then Congress can do it as well, okay? So C is your best answer there. All right? All right, I will be getting your quiz up for the week tomorrow morning, probably. If I'm lucky, I'll get it done tonight, but it'll probably be most likely tomorrow morning. Same as before, it'll be due on Monday at 11 o'clock, okay? You guys take care. Have a good weekend.
you.
Thank
Professor,
you.
Bye, you too, Professor. Thank
Have a
you.
good weekend.
bye, thank
Okay.
Oh.
Oh, did a dog just wish me a good weekend?
I have a quick question for you, Professor.
I heard that. You guys take care.